Okay, good afternoon, everyone. My name is Martin Phillipson, and I'm Dean here at the College of Law. As we gather here today, we acknowledge we're on Treaty 6 territory and the traditional homeland of the Métis people, and we pay our respects to the First Nations and Métis ancestors of this place, and by doing so, we reaffirm our relationships with one another. I'd like to begin by thanking McKercher LLP for sponsoring our lecture series, and I'd like to invite Janine Lavoie-Harding to bring remarks on behalf of the firm.
Thank you, Martin. Good afternoon. I'm a partner in the Saskatoon office where I advise and I represent debtors and creditors in restructuring and insolvency proceedings, as well as clients in commercial litigation matters. McKercher is very proud of our relationship with the College of Law. As a proud College of Law alumni, I personally know how important these types of events are for our students. It's a great opportunity to hear about timely and interesting topics from experts in the respective fields. I look forward to your lecture, Dr. Lund.
The Estey Chair in Business Law was established in 2012 by John and Bill Estey in honor of their father, the late Willard Bud Estey, former Justice of the Supreme Court of Canada. Their donation of $2 million is the largest ever private donation to the College of Law. Chairholders teach courses related to business law, conduct high-quality research, and share their knowledge and insight by engaging with the wider legal community. The chair has previously been held by Callie Jordan, Rod Wood, and most recently Michael W. Milani, KC. This term, our Estey Chair in Business Law is Dr. Anna Lund. Anna is an associate professor at the Faculty of Law at the University of Alberta. She researches and teaches in the areas of bankruptcy and insolvency, debtor-creditor law, civil procedure, access to justice, and housing. Dr. Lund's current research interests include foreclosures, medical bankruptcy, and alternative incorporated forms. Her book, Trustees at Work, Financial Pressures, Emotional Labor, and Canadian Bankruptcy Law, was published in December 2019 by the University of British Columbia Press. Her work on environmental liabilities in insolvency has been cited by the Supreme Court of Canada, and she has articles forthcoming in the Alberta Law Review on defenses available to residential borrowers in foreclosure proceedings, in the McGill Law Journal on the Mountain Equipment Cooperative insolvency proceedings, and in the University of British Columbia Law Review on using the oppression remedy to resolve disputes in religious communities. I think you can see that Anna Lund is very well qualified for the Estey Chair. I would also like to acknowledge that Bill Estey is watching us today online from Ontario, so welcome, Bill, and thanks again for your support and that of your brother. And now, please join me in welcoming Dr. Anna Lund.
Thank you. I'm going to be talking today about foreclosure proceedings, which is where a lender sells property because somebody hasn't been paying their mortgage. And the big question I've been thinking about is how judges ensure that homeowners are granted the protections that they're entitled to, even if they aren't showing up in court. Now, a big theme running through my research is home, and my family has been calling Treaty 6 and Treaty 7 territory home for 5 generations. Something I like to think about is about how my ancestors found refuge on land through a process that resulted in the displacement and dispossession of the Indigenous people who had and continue to live there. The Cree, the Blackfoot, the Métis, the Nakota Sioux, the Iroquois, the Dene, the Ojibwe, the Saulteaux, the Anishinaabe, the Inuit, and others. So I want to start by acknowledging my place in this difficult history. I want to thank the McKercher firm for sponsoring this talk series. I want to thank the Estey family for endowing the research chair, which I'm very grateful to be holding this semester. And I want to thank the Faculty of Law here for welcoming me into the faculty and for making this possible, given my family obligations in Edmonton. I've been doing a lot of flying this semester, and yesterday at the airport, somebody asked me, one of the security people, "Are you flying somewhere warm?" And I said, "I'm going to Saskatoon." And we laughed and we laughed and we laughed. So I want to start with a bit of an admission, which is that I went for a run this morning because I wanted to get a picture of the steam rising off the South Saskatchewan River by the railroad bridge. But when I got to the perfect vantage point and I pulled out my camera, the battery had died because it was so cold. So Instead, and because I don't want you to think that I'm laughing at you, I am truly laughing with you. Here's a picture of me out on a frolic on a -30 day in Edmonton. You can see our beautiful new building in the background. We're going to go on another frolic later in this lecture, but I promise you that it will be of the intellectual sort, not the frigid sort. So there's lots of reasons that I'm excited to be spending time in Saskatoon this year, and one of them is that my partner's family is from Saskatoon. So this is a picture of his grandfather, Jim Gerglis, who was an immigrant from Greece. He ran and there's a crescent named after him. He was a very talented trap shooter. He ran a restaurant here in town with his brothers called the Elite Cafe. And my partner's father is a graduate of this law school, the class of 1956. He graduated from here before he went out to Alberta, practiced law, became a judge, and unfortunately we lost him just this past December. Another reason that I'm excited to be in Saskatoon is it's giving me lots of chances to talk about a favorite book of mine, which is Diane Warren's novel, Cool Water. Cool Water tells intertwined stories of a dozen characters, all of whom live in a small community, a made-up community called Juliet, Saskatchewan. Now, Juliet is located in southwestern Saskatchewan, and one name for that part of Canada is Palliser's Triangle. It's named for John Palliser, who visited the area in the mid-19th century and recommended against farming crops there because it was so dry. Notwithstanding this advice, the government of Canada encouraged people to settle there, and in the 120 years since they started settling, the dry conditions have posed a challenge. Now, my grandmother, here's a couple of pictures of her, Eunice Samus. She grew up on the far west end of Palliser's Triangle near Blackie, Alberta. During the 1930s, she worked in a one-room schoolhouse. It is no longer standing, but it looked like this one. And she told this story about getting caught in a dust storm. It was so dry out there. She got caught in a dust storm that she couldn't see anything. She had to use a barbed wire fence to find her way home, and she actually ran into the side of her house before she saw it because it was so dark with the dust in the sky. So, back to Palliser's Triangle. Now, the dryness of Palliser's Triangle reaches extreme levels in the Great Sandhills of Saskatchewan. And Juliet, this fictional town, is located on the border of the Sandhills. The book Cool Water is set in a contemporary moment where there's a drought, and the town is struggling through this drought. Now, of particular interest to commercial scholars, because this does tie back to mortgages, is how the drought impacts the characters. So one of the characters, Norval Birch, is the manager of the local bank, and he is in the position of foreclosing on his neighbors. And two of the other characters, Vicky and Blaine Dolson, are in the process of losing the family farm after repeated defaults on their mortgage. So what this book does really well, from the perspective of somebody who's interested in mortgage law, is that it tells us that foreclosure is a process that can extend over a long period of time. And it shows us how foreclosures have serious impacts on everybody who's involved in them. Now, there's a growing body of empirical evidence that foreclosures and other processes of involuntary unhousing, like evictions, have serious negative impacts on the people who are being unhoused. These include physical and mental health problems, shame, stigma, disruption to children's education, and even lower voter turnout. There's also negative impacts on the communities where these unhousings occur. If there's a sufficient number of foreclosures in a community, it will depress the housing prices. And the forced relocation severs the relationship between the person leaving and their neighbors. This erodes the broader community's sense of cohesion and security. So given the significant negative consequences for foreclosures on homeowners, an interest of mine is how the law governing residential mortgages ensures that borrowers aren't needlessly unhoused. Now, my own interest in this area has grown out of my work with the Court of King's Bench Amicus program. So here is a picture of our law courts in Edmonton, some beautiful brutalist concrete structure. So what's the amicus program? The amicus program is made up of volunteer lawyers, and they show up at court to assist self-represented litigants who are appearing in court. They meet with them for the first time the morning of the court hearing, minutes before they appear in court, and they provide them with guidance about the legal issues that they are in court dealing with. They may negotiate with opposing counsel for them, and they may also speak to the court on their behalf. Now, I worked with the program from its launch in 2015 up until the time that the pandemic shut down the courts in 2020. We helped with all sorts of different issues, but a significant number of the people that I saw were there because they were being foreclosed on. So I've been slowly wrapping my head around mortgage law, and I found it difficult. Not because it's complicated commercial law. I quite enjoy complicated commercial law. What I have found difficult about mortgage law is two things. First, it's very local. It differs from province to province, but it's also shaped by the practices in sub-provincial areas. So for example, the way that mortgage enforcement law is practiced in Edmonton varies from how it's practiced in Calgary. And this points to a second thing that I find tricky about the area. So much of it is based on how everybody's practicing it. And this can be hard to grasp if you are not at a firm where people are already practicing it. If you are, they can explain to you this is how things are done. If not, trying to figure it out on your own can be difficult. And this may be true to many different areas of law, and I've just encountered it as I try to figure out mortgage law. But I think a lot about homeowners. Homeowners who can't afford lawyers because they're going through a foreclosure proceeding. They have to navigate this on their own, and how do they figure out what's going on? Now, a sentiment I've heard sometimes expressed is that it doesn't really matter what the homeowner does because there aren't any defenses to mortgage enforcement proceedings. If you can't pay, you're going to lose your house. So there's some truth to that, but in some cases there will be defenses. And in most cases, there are protections. In Alberta, we have two key protections for borrowers. The first one is time. In Alberta, we have redemption periods, which is a pause in the foreclosure proceeding, which allows a homeowner to do things like pay off the arrears owing on the mortgage, refinance their mortgage with a different lender, or if there's not a financial solution, they can try to sell the house outside of foreclosure proceedings and hopefully get a higher sale price for it. In Alberta, we have a default 6-month redemption period, but it doesn't apply to all mortgages. The second key protection is protection from personal liability. So a borrower can face personal liability if their house sells and it sells for less than the amounts outstanding on their mortgage. Now, the law may restrict the lender's ability to collect this shortfall, what we call the deficiency. This is a feature of both Alberta and Saskatchewan mortgage law, and they are the only two provinces with legislation protecting borrowers from deficiency judgment. This legislation dates back to when my grandma was teaching in her one-room schoolhouse to the 1930s. It was part of the legislative response to the extreme financial distress created by the Great Depression. In both Saskatchewan and Alberta, this protection does not apply to all mortgages, but the scope of who it applies to is quite different between the two provinces. So, to lay claim to either of these protections, a homeowner would need to know that they exist, they'd need to know the scope of the protection, and they'd need to know enough about their mortgage to figure out if they fell within the protection or not. Now, I have a piece coming out in the Alberta Law Review that looks at the scope of borrower protections, and it's intended to guide lawyers and legal intermediaries who are helping borrowers go through foreclosure proceedings. The paper also looks at reform initiatives. So in Alberta, back in 1994, the Alberta Law Reform Institute released a report calling for reform to the area of mortgages. This has never been implemented. In Saskatchewan, there is a reform process underway. So there is a 2020 report, and that 2020 report is based on work done by Ron Cumming, of course. I was going to get to Ron Cumming at some point in a lecture about commercial law. Another reason that I've been really excited to be in Saskatchewan is because they have such a tradition here of excellence in commercial law. Ron Cumming has really made a huge mark on this field, including by mentoring my mentors, Tamara Buchwald and Rod Wood. Ron is still hard at work. I was talking with him just last week about all the projects he has on the go. And this tradition of excellence, of course, is being carried forward by Dr. Banksand here at the faculty. Now, Professor Cumming, in a paper discussing the need for reform, quipped, "Maybe it is acceptable to retain a system that is so complex that a full understanding of it is reposed in a few legal high priests who know the secrets on which important aspects of society are based." His point, of course, is that this state of affairs is not acceptable. Reform is needed. But in the meantime, borrowers are not completely without safeguards. Why? Because in Alberta, Saskatchewan, and some other provinces, we have a judicial sale approach to residential foreclosure proceedings. What does this mean? This means that a judge is overseeing the foreclosure proceedings. And this can be contrasted with some provinces like New Brunswick and Ontario, where there is a power of sale process. So the lender can sell mortgaged properties without having to go to court, without that court oversight. In 1994, when the Alberta Law Reform Institute was considering whether or not it should keep this judicial sale process, they noted that it was slower for lenders, that it involved more court costs for lenders, and that it took up limited court resources. Notwithstanding those critiques, they recommended keeping it. Why? Because they saw it as providing safeguards for both borrowers and lenders. There is a judge overseeing the process. But what does this actually look like? And now I promised you a frolic of the intellectual sort, and that's what's going to happen next. So my title was Foreclosure Proceedings in Lawyerless Courts, which is a bit of a weird title because there's always lawyers in foreclosure proceedings. But this is a reference to a really exciting empirical project that has been ongoing in the States by a group of 4 scholars, Anna Carpenter, Jessica Steinberg, Colleen Shanahan, and Alex Mark. They have been researching state civil courts. What's interesting about state civil courts? Most parties are unrepresented. And one of the questions they have asked is, how does judging change when there aren't any lawyers in the courtroom? So if you think about the adversarial system of justice, which the Canadian court system is based on, we rely on lawyers to put evidence before the court, to argue about the laws that apply in the case, and the judge is sort of this passive recipient of evidence and legal arguments who eventually decides in favor of one party. Self-represented litigants struggle in this model. They struggle to elicit evidence, they struggle to argue law. So judges need to take a more active role. What does that look like? In the American project, they identified 6 different types of active judging: adjusting procedures, explaining law and process, eliciting information from the self-represented litigants, raising legal issues, referring parties to court-based and nonprofit service providers, and facilitating negotiation between the parties. Now, how did these scholars identify what's going on in courts? Well, they went out and they interviewed judges, and they also went out to observe state court hearings to see what was actually going on in those hearings. They selected civil protection order hearings, what we might think of as common law restraining order hearings. In these, both parties are commonly self-represented. So you have 2 self-represented litigants facing off against each other. But in their work, they noted that other types of hearings raise different types of issues. I'm going to read this quote to you. In the non-family civil law matters that dominate state court dockets, including debt collection, I'm going to pause here, foreclosure, and landlord-tenant cases, Unrepresented defendants are likely to be low income or at least temporarily struggling financially. On the other side of the case, these defendants face sophisticated parties, landlords, banks, credit card companies, and debt holders represented by lawyers. We should explore how judges respond when they are a key source, if not the only source of information, assistance, and guidance for pro se, that's the American term for self-represented, defendants facing repeat player lawyers. Do they adhere to formal procedures, maintain a passive posture, or develop new procedures? How do they manage cases where only one party is capable of engaging in meaningful factual development and legal argument? Do they help self-represented defendants develop defenses? So recall that the Alberta Law Reform Institute argued that the value of judicial sale proceedings as opposed to extrajudicial power of sale processes is the oversight function of judges. What does this look like? Well, taking up a page from these American scholars, I have been watching foreclosure proceedings in Alberta courts to try to better understand what role our judicial officials are playing in overseeing foreclosures. I've sat in on court for 3 months. I've seen a whole range of court applications, including, to this point, 57 mortgage enforcement applications. I'm not done yet. I'm still learning a lot, but I'm going to offer some preliminary observations. Now, most foreclosure matters are heard by our applications judges. Until last year, we called these our masters of the Court of King's Bench. Most foreclosure matters are heard in morning chambers. So I want to tell you a little bit about morning chambers. In morning chambers, it usually lasts about 2 hours, and you have up to 25 matters scheduled on the list. These are intended to be short matters. If you're going to take more than 20 minutes, you're supposed to arrange for a special hearing, a half day or a full day. Applications judges get the material for morning chambers shortly before court starts, and they have very little time to review them. And they hear a whole range of matters. They hear civil litigation matters, judgment enforcement, builders' liens, and foreclosures. So I've been going to morning chambers to watch foreclosure proceedings, and I've seen examples of all the methods of active judging identified by Anna Carpenter, including in the context of foreclosure proceedings. So, adjusting procedures. A borrower shows up with appraisal saying my house is worth X, but they don't have it attached to an affidavit. The applications judge works with lender counsel to figure out how they're going to get that appraisal on the court record. Explaining law and process. A borrower shows up with a printout from the internet that says, I'm protected from deficiency judgment, from personal liability, and the applications judge has to explain to them, your mortgage falls outside of the scope of that protection. Eliciting information. You see them asking borrowers for key details. Are you still living in the property? Do you want to hold on to this property? You see them raising legal issues, but also problem solving, okay? Often they're problem solving for self-represented litigants. Sometimes they're problem solving with or for the lawyers. For example, there was a foreclosure application where the borrower had died. The applications judge indicated that that raised a civil procedure problem. There was a stay under Alberta's rules as soon as the borrower died. The applications judge then wrote a clause into the order that she granted indicating that she was lifting the stay. Referring parties to court-based and nonprofit service providers. You see the applications judges referring borrowers to the legal clinic in town. You also see them recommending that applications borrowers talk with insolvency trustees about their options. And facilitating negotiations between parties, you see the judges standing matters down so that the borrower and the lender's counsel can step outside to try and negotiate a payment plan. But when it comes to foreclosure proceedings, the story is only partially about self-represented litigants appearing against a lender's lawyer. So I am now revising the title of my talk, Foreclosure Proceedings in Borrower-less Courts. It really does not roll off the tongue. Why am I calling it this? In 25% of the matters I've seen, the defendant has appeared either self-represented or by a lawyer. In 75%, there's nobody there for the defendant. The defendant is absent. So the question then that I think is really interesting is, how do you judge when one party is absent? And this is not a question that is limited to foreclosure proceedings. Professor Sarah Buehler, in her study of eviction proceedings here in Saskatchewan's Office of Residential Tenancies, found that tenants only show up 37 to 38% of the time. So in foreclosure proceedings, what are judges doing when the defendants don't show up? They can't assist the defendant because there's no defendant there to assist, but they're still ensuring that fairness is done. And I've seen this done in a couple of different ways. First, they're asking about absences. So at the start of any hearing where there's only one party there, the judge always asks about whether service is in order, right? Has the other party been provided notice that you are doing this today? And in an adversarial process, that's where things end, right? If the other party has decided not to show up, so be it, as long as they've received sufficient notice. What you see in foreclosure proceedings, though, is applications judges go beyond that. Are you expecting them to show up? Should we stand this down to see if they're trying to find the courtroom? Do you have any idea about the position that they take on this matter? Those are the sorts of questions that judges are asking. And they elicit information about the borrower and their position. Sometimes lenders' counsel says something like, they have moved out of the country and told us that they're not taking a position on this matter. Sometimes lenders' counsel says something like, I've been in touch with them, they're suffering from serious depression, I'm not expecting them to show up today. In that case, the applications judge then took account of that information in crafting a sale order that gave the borrower a little more time to move out of the house. Something else I've seen is testing evidence. So once lenders get to the point in the proceeding where they are selling the mortgaged property, a central concern of the court is whether the price is fair. Are we getting a fair price for this house? This is important for the borrower. Why? Because if they have equity in the house, if they have more value in the house than is owing on their mortgage, and a lot of people, that's their retirement savings, they're going to get that if the house sells for a fair price. If they don't have equity and they aren't protected from personal liability, the higher the sale price, the lower the deficiency judgment against them after foreclosure proceedings. So lenders put evidence of value before the court, often in the form of an appraisal from a real estate appraiser or a comparative market assessment from a realtor. And what I've seen is the courts reviewing these documents to try and understand how the person who has valued the property came up with that number. What did they use as comparables? What sort of adjustments have they made for the condition of the home? Does this look like a fair appraisal? I also see them ensuring consistency with local practice. So there was an application where a lawyer was applying to list a home on Kijiji. This is a process that is often used when houses are being sold and there's quite a large deficiency. So they were listing it for sale on Kijiji. The applications judge asked the lawyer, how long do we usually post these listings? The lawyer said, I'm not sure. The applications judge looked at a similar order that they had granted earlier in the day and used the time periods from that one. So you see they're ensuring consistency between how different borrowers are being treated. And this is really important because it goes back to what I said earlier, that so much of what mortgage enforcement is what people do. It's the practices. They're also investigating legal entitlements. They're ensuring that lenders are entitled to the relief they are claiming. So in an application by a condo corporation was foreclosing on a unit in a condo because the unit owner hadn't been paying their assessments. They were asking for costs at a higher level, at a solicitor-client level. And the application judge asked the lawyer to take them to the part of the condo bylaws that entitled them to that cost. Show me that you are entitled to this. Now, lenders' counsel plays an important role here too. And when you see experienced lenders' counsel, they can anticipate what facts the judges are looking for, and their submissions follow a careful formula. They set out these facts, and then they draw the judge's attention to any unusual facts on a given case. So my own preliminary assessment is that application judges do play an important oversight function in these enforcement proceedings. But we also need to be clear-eyed about challenges, where applications judges are limited in their ability to play this oversight role. One of the challenges, of course, is limited time. They get the materials shortly before chambers start. They do not have time, either before chambers or during, to carry out an in-depth review of every file. And so what you see is they carry out in-depth reviews on files where there is some sort of flag, something unusual. If the value attributed to a house over the course of the foreclosure proceedings has changed drastically, that may warrant a closer look. In cases where the defendants don't appear, okay, where there's no borrower, they're really stuck with, the applications judges are stuck with a limited evidentiary record. There is no competing evidence, okay? It is hard to say that a appraisal is unfair if you don't have a competing appraisal. And you can see this. Sometimes borrowers do bring competing appraisals, and then the applications judge can put them side by side and figure out why this one is high and why this one is low. But when you're just looking at the one appraisal and you have nothing to compare it to, that's a much more difficult process. There's also no evidence of information that may be relevant from the borrower. When borrowers show up, they may raise concerns about the calculation of the amount owing, whether it took account of all the payments that they've made. And this type of evidence just doesn't get before the court if the borrower doesn't show up. So that brings me to 3 questions that I've been grappling with. One is, how do we support active judging? How do we support judges in these roles where there is only one party present? Now, the American researchers have indicated that it's really important to provide ethical guidance to judges on how to conduct themselves in situations that depart from the adversarial process. And in Canada, the Canadian Judicial Council has developed a guidelines for judicial officers dealing with self-represented litigants, okay, so where somebody is self-represented. This has been endorsed by the Supreme Court of Canada in the Pintea and John case. But my question is, how well does this apply to a situation where it's not a self-represented litigant, where it's an absent litigant? A second question I've been asking is, what type of ethical obligations should be imposed on lawyers practicing in an area where the defendant is commonly absent? Now, in our Alberta Code of Conduct, we have the following direction. When opposing interests are not represented, for example, in without notice or uncontested matters, or in other situations in which the full proof and argument inherent in the adversarial system cannot be achieved, the lawyer must take particular care to be accurate, candid, and comprehensive in presenting the client's case so as to ensure that the tribunal is not misled. This situation creates an obligation on the lawyer present to prevent a manifestly unjust result by disclosing all material facts known to the lawyer that the lawyer reasonably believes are necessary to an informed decision. Okay? There's similar language in the Saskatchewan Code of Conduct. I find myself wondering if this is sufficient. The last sentence, all material facts that a lawyer reasonably believes are necessary to prevent a manifestly unjust result. That seems to provide a lot of room for questions. Also, if borrowers are absent from the foreclosure proceedings, who is holding lawyers to account under this threshold if they fall short? A third question I have is, where are all the borrowers? Should we be concerned that they aren't showing up? And maybe it depends on why they aren't showing up. If they're all just satisfied that they're getting the protections to which they're entitled, and so it doesn't make sense for them to take the day off work to appear in court, that's one thing. But we have reason to believe that other factors are in play. So the Alberta Law Reform Institute back in 1994 says one would expect borrowers to come to court to present their side of the case. Unfortunately, human nature works against logic in this situation. We receive strong indication, although anecdotal, that many borrowers fail to come to court because they are embarrassed, intimidated, or naive, not because they would not benefit from presenting their case before the court. Professor Buehler discussing tenant absences from eviction hearings in Saskatchewan, suggested that they face barriers to attending, lack of transportation, lack of childcare, lack of technology necessary to sign in for a virtual hearing, but also that they have little trust in institutions like the legal system, and so they don't believe that showing up matters. So, do we need to do more to support the involvement of borrowers to ensure that they are not needlessly unhoused? I am about to stop asking questions and turn it over to you guys to ask questions, but first, I wanted to invite you to a book talk. Leah, Howie, and I are going to be having a book club to talk about cool water. We can talk about the foreclosure aspects. We can talk about other aspects. It'll be March 22nd from 12 to 1:30 in the Indigenous Law Center. And Diane Warren, who is the author of the book, who is a Saskatchewan author based in Regina, will be joining us for part of the meeting to answer questions about her book. So I would encourage you to pick it up and come join us. And with that, I will stop with my questions and turn them to yours. This is a picture of my grandparents from 1939, which is right around when we enacted protection from deficiency judgments in Alberta. And you may think that they are smiling about the changes we made to the Judicature Act, but they are not. This is the day that my grandfather became a United Church minister, and that's why they've got such nice smiles on. All right, thank you.
So, questions? And if you could use the microphone so people can hear online.
Thanks, Anna. This is really, is it on? Can you hear me? It is on? Okay. This is really interesting because it takes me back. I remember doing foreclosure proceedings from a borrower or from a lender's perspective, and I remember the paralegal that did it never wanted to give you the file until like minutes before you had to be in the courtroom because he didn't want your time billed on that file. So as a lawyer on the other side of it, you were frantically trying to make sure you actually knew what the files were before you were walking in too, which is kind of a weird thing, but probably doesn't happen in any other place. But I remember kind of being on the other side of that, kind of freaking out for a little while, going, okay, what do I need to know? I'm interested about when, like, you mentioned the Amicus program that you've got, and I know, showing up in court just before this all happens, that's interesting. Do you, was there any ability to reach out to borrowers? Did they get advance notice that, look, if you show up at the courtroom, there is going to be someone there that's going to help you navigate things and potentially, and did you see any difference, say post or during the pandemic when maybe that outreach wasn't available, and pre-pandemic when it was, in terms of the rates of people that were actually showing up to speak? It just seems to me that like having, maybe a requirement to say, and by the way, if you're not represented, there will be people there to help you, could kind of overcome some of that embarrassment or naivety or intimidation that people might feel. But I just don't know if those interventions were in place or if they're contemplated as part of your upcoming paper that's coming in the Alberta Law Review.
So I'll say a couple things. That's a great question, Heather. First, a lot of lenders counsel who practice in the area commonly, if they're expecting somebody to show up, will consider scheduling it for Wednesday, which is when Amicus is there, because it's often easier for lenders counsel if Amicus is present, right? There's a lawyer there making sure that the borrower understands what's going on, and that's often really helpful for everybody involved, right? So I'd say that there's not a mandatory aspect, but there is a practical aspect. During the pandemic, one of the retired masters, she retired before they did the name change, so I'm not entirely sure if we call her master or applications judge, but She led a number of initiatives that were designed to provide support to debtors. One of them was the Alberta Consumer Debtor Project, which is ongoing, and that is a space that provides debtors with a number of different supports, including access to different sort of public legal education resources, but also the ability to connect with a lawyer before they show up in court. And that's so important. Often those files, they're able to negotiate some sort of non-court arrangement with the lender. But in situations where they're not, the challenge with doing amicus, I mean, yes, you're there, and yes, you can explain the law, and you can help speak for them in the court, but you can't help them develop evidence, right? They come and they tell you their story about why they have a defense or how they've made payments, but my experience is that self-represented litigants never understand that they need to put their evidence into an affidavit, right? They think that they're going to show up at court and they're going to be called onto the stand and they're going to have a chance to tell their story. And that's not how applications judge chambers works. Everything has to be in a written affidavit. So on slow mornings, when I only had one person in amicus, I could try and print out a short affidavit and have them swear it right there, but that was unusual. That evidentiary development needs to happen beforehand. Yeah, thank you.
So that's interesting. So when we think about process changes, like it looks, activist judging is important, but as you're saying, they still need the evidence. And so it makes me harken back to some things we were talking about in terms of different models. This was at our Dean's Forum just on Friday, and we were talking about different models in family law and looking at things like inquisitorial systems or different types of tribunal type systems, which might take things away from we need an affidavit when we know most people are lawyerless, or a lot of the borrowers are lawyerless or pro se or self-represented, that maybe we need to rethink the process in general on these types of consumer, residential mortgage, that type of thing. I don't know, it just made me, you probably have thoughts on that.
Yeah, I mean, it makes me think of the former head of the Civil Resolution Tribunal in British Columbia, whose name I'm blanking on. Shannon Salter, that's right. And she's called to do away with affidavits, right? Why is a written statement that you sign not legitimate, right? Why do we need to go through the process of swearing an affidavit? So I think that there is an important conversation to be had there. And then there's also a question about, does it make sense to continue to do these through a judicial process? Does it make sense to, like residential tenancies, try and do them through an administrative process? I don't know. I mean, there's some pretty trenchant critiques that have been made of the residential tenancy system, and I'm not sure that that's the fix.
And can I ask? Oh, sorry, Mark.
No,
Okay.
go.
So then that takes me to my next question about judicial oversight versus say the Ontario model where you don't have that. So we recognize, even you're citing from the Alberta Law Institute's 1994 proposal, still saying that we still think that there should be judicial oversight. We do recognize every time you go to court it costs money, right? And those costs are going to be taken out of the sale proceeds, right? And so I'm just from a pure pragmatism here and dollars and cents, if we have that few people showing up in court and the majority of borrowers not, and unless we're going to make fundamental changes that we think somehow will give us better results, when we really don't have a lot other than purchase money, mortgage protection, and redemption periods, should we say, well, maybe this isn't worth the cost to have judicial oversight if it's not fulfilling the mandate that we think it should?
Yeah, I mean, I guess I'd say two things about that. One is I do think that the judicial oversight function is serving an important role in these files. There's the ones where they look closely, and there's always the possibility that they could look closely, right? And that possibility, I think, has a disciplinary function for for the lawyers who are making these applications. The second thing, and I mean, I haven't seen recent numbers on this, but in the 1994 report, the Law Reform Institute went out and asked lenders, is it more expensive to foreclose in Alberta because we have this judicial oversight process? And I think Scotiabank said, oh yeah, much more expensive. And all the other ones said, no, it's a similar cost in Alberta versus other jurisdictions. So I think that what I'm saying in my presentation is not absolutely let's continue with judicial oversight. I'm saying I see it as serving an important value, but what you're saying, and is I think right, is that needs to be balanced against the costs of this process.
Well, just to be clear, I was mostly playing the devil's advocate. I actually think whatever your report's going to, in terms of your observations, are going to go a long way in trying to inform that decision about future changes, if any, that should be made in that area. So thanks for that.
Thank you.
So I'm not a commercial lawyer, so take this question at that sort of value. But given the state of the housing market, very high interest rates, there's likely a tsunami of foreclosures coming in the near future where a lot of people are going to be defaulting on mortgages. Is there anything sort of in this that courts and others should be ready for that and maybe be providing more advice? Because I can't imagine there not being a veritable tsunami of foreclosure proceedings in the not too distant future.
Yeah, I mean, it'll be interesting because we've been expecting the tsunami of foreclosure proceedings for a while now, and they haven't materialized. So, it may be that banks recognize that going through that many foreclosure proceedings all at once is bad for them because it depresses the housing market, right? So there's that question mark. But what it makes me think about. I see how it's really helpful for borrowers when they show up, right? When they show up and they put their case before the court is able to take account of that, and within the legal limits available to them, craft a proceeding that responds to the needs of the borrower. But it's also incredibly time-consuming. I mean, realistically, we could not have our courts function in the way that they're functioning if all the borrowers showed up. And so, yes, it would be great to have all the borrowers there. Maybe part of the answer is civil legal aid for people who are going through legal and housing processes like evictions and foreclosures, because that would be, you see self-represented litigants and the kind of time that it takes to deal with those files versus files where amicus is there. And even though they've just got the file the morning of, I think it's a much smoother process. So part of me thinks that the answer is civil legal aid, but realistically, if we have a huge number of foreclosures, I question how the judicial sale process is going to be able to manage that.
Any more questions? No? Okay, then I'm going to ask Nisha to provide a gift and some words of thanks on behalf of the college.
Hi, everyone. On behalf of the College of Law, we wanted to thank Dr. Anna Lund for coming and spending the time to talk about some very large issues within housing, but also into the access to justice issue. We want to thank you so much for all of your inspiring words, and thank you. And we hope you enjoyed your time presenting. Thank you.
Thank you.